Uh, Thanks for the question, Diti. I knew this would come up. Twin bill condition. So, by twin bill condition, we mean that something extra is required to be done. In common parlance, like take up a case of murder or rape, a person would have to satisfy that he has not committed the offense and the material against him is not very nice. He will have to certify, he have to prove before the court and show before the court that there are no antecedents before him. Like he has not been indulging in such offenses previously. His criminal record is clean. He has to show to the court that he is not a flight risk, which means he is not going to run away. He will come and face the trial. It also means that he has to show to the court that he will not be tampering with the witnesses or putting the potential witnesses under the fear or giving allurements to them. He has to just show that. But let's assume he is accused of committing an offense under NDPS Act. Like the allegation against him that he was found with 2 kilograms of cocaine. That's the commercial quantity of cocaine. So if he is accused of that offense, that he will have to show that which I have just mentioned, like in a murder case. Besides, he will have to show in the court that there are reasonable grounds to believe that he has not committed this offense. He has to address the merits of the case. It's like getting into a mini trial. But by appreciating the material on record, he has to show and make the honorable court believe that the material against him is not sufficient and there is a good likelihood that he will get acquitted in the offense. So he is supposed to conduct a mini trial in a bail hearing and come out favorably with the court, showing that there are reasonable grounds to believe that he is not accused or is going to be proved guilty in this whole trial. That extra burden is called twin bill condition. That can be found in Section 37 of NDPS Act. That can be found in UAPA. That can be found in various special acts. I went into the detail in NDPS Act because we had a judgment readily available, and with the help of judgment, I could show it to you. So by twin bill condition, we mean that you will be showing to the court the normal bail things. Besides that, you will also be showing the merits of the case that there are reasonable grounds to believe that you are not guilty or likely to be proved guilty. So that's the harder part. So I hope I could answer it, but it's a very complex thing. That's why it takes some time and effort to appreciate it and explain it to you.
Thank you. So we have next question from Mr. Saha. How long a charge sheet should be?
That's a very interesting question, honestly. It depends on the nature of the offense. In traditional criminality known as murder, theft, rape, charge sheets are not very long. Like they have eyewitnesses account, they have maps, they have some medical reports. That's it. What else they would have? Some write up, as I give write up to you people in every lecture. There are judgments and write ups. There would be some write up by the IO. What else could be there? But in charge sheet of like economical offenses, like ED offenses, like socioeconomic offenses, forgery cases, cheating cases, some builder having been accused of forging the home buyers and the number of home buyers is like thousands, then in those cases even the god won't would not know the length of the charge sheet. Some of the trials which I have done, I have come across charge sheets which are like as lengthy as 10,000 pages. But believe me, a lengthy charge sheet doesn't guarantee you the conviction. The conviction rate in ED is very low, and that has been the concern of apex court. So yeah, it depends on the case. Socioeconomic offenses, offenses committed by very educated people are very bulky because there is a trail to be found. A lot of documents have been doctored. So that requires a lot of documentation. The traditional criminality of stabbing and all. That's very simple and it gets summed up in like 100 and 200 pages.
So we have another question. What is the day from which the counting of for 90 days starts in the case of default bail?
The day of your arrest, the day you are picked up and put behind the bars. The clock starts then and there.
Mhm. So we have next question from Mr. Anurag. There is this condition for bail in every special statute which says the accused should prove to the court that for further time for investigation will default bail be granted.
Default bail is
Oh,
always
sorry, sir.
there.
Sorry, sir. I mixed the questions. There is this condition for bail in every special statute which says the accused should prove to the court that he is not guilty, but to prove whether he is guilty or not, it takes a full trial. How can this be a condition for bail?
Yeah, that's why I said it's very tricky. That's why I say that a lot of jurists have written vehemently against it. You can do your own research and you will find that it has been condemned by everyone. Even I find it difficult to prove in a hearing or two that how I'm going to make a court believe that I am innocent. It will take a trial to prove my innocence. That's why trials are conducted. But if you put the cart before the horse or horse before the cart, the problem will start. So there is a sequence by which we go. But in such offenses, that sequence gets disturbed and eventually you don't know what to do, what not to do. But at the same time, we need to see what they are trying to curb. Like drug menace, drug menace is there in Punjab. It's not there all over India. But if you see the countries like United States, where it has become a menace, it's corroding the youth, it's corroding the future of the country. When you are faced with such things, legislature, they are made by people only. People like you and me only go to parliament. I hope people here in this session get lucky and go to parliament. These people only make the law. And when you see a problem as big as drug abuse, you come up with these stringent provisions. At times, those provisions don't work, but you try to find solutions, and at times, solutions are worse than the ailment you are trying to cure. That's the life.
Thank you, sir. We have next question from Mr. Manoj Roy. When the police fail to file charge sheet within the prescribed time and if police ask for further time for investigation, will default bail be granted?
Default bail is granted when the investigation is not completed within the given time and you have done your time in the jail. So, default bail is like mathematics. Imagine you have been accused of committing an offense which was punishable for life. So, you are in jail. Within 90 days, a charge sheet had to be filed. Charge sheet means investigation has been completed and they file a white paper against you. If they have failed to do so, then you have a right for default bail. It's that simple. It's mathematics. Once the mathematical formula is completed, you are entitled to bail. There is no if and but. In default bail, there is no if and but. There are only conditions to be satisfied.
So we have next question from Mr. Hemant. Regular bail in POXO case.
It's a difficult thing. Lately, like for a case, I had to go to Maharashtra to secure a bail, and it was very difficult, believe me. In POXO, there is no twin condition, but it's very difficult because the nature of the offense is there and minors are involved. But in POXO, there is a judgment of Dharmender Singh versus State of Delhi High Court, Honorable Delhi High Court by Honorable Justice Anup Jairam Bamani, and that sums up law very well. It says that POXO by name has not to be the decisive of the whole issue and conclusive. You have to see the merits of the case. You have to see like if there is teenage affection, then you have to see it lightly because it might be consensual. Though those people are not mature enough to consent as per law, but it might be consensual. The boy might be just 18, the girl might be just 17. They might have had something, some affection for themselves. But on the other hand, if the girl was of 13 years and the other person was a father or a elder brother of 35 years, in those cases, it has to be looked very seriously and it deserves the condemnation and the bills have to be rejected. So real life human considerations have to be seen in those cases. And I'm happy that law in that direction in India is evolving. Parliament could not come up with those suggestions, and in the vacuum, judiciary has come up with some real life considerations and factors, and it has been helping the people on ground. So in FOXO, there is no twin bail condition, but the facts affect the law a lot, and the sentences which could be imposed are very harsh. That's why the grant of bail is not that.
Um, Thank you, sir. We have next question from Mr. Ashutosh. Sometimes judges ignore the accused side in case of Section 409 of IPC. Only they see only only they see the figure of amount, and on the basis of that they deny the bail. Why?
So for that, this is why I begin this lecture with Gajanan Gore judgment. It says that, see, the gravity of the offense has to be measured by the quantum of punishment applicable, not by the amount involved. So anyone who is saying that the quantum of amount is large, that's why we are not granting bail. That's strong appreciation of the law. The right appreciation of the law would be considering the sentence which could be imposed and appreciating them. So anyone giving those considerations is not appreciating the law properly, and you need a good lawyer in that case.
We have next question from Ms. Meenakshi Das. What is the difference between twin bail and bail in non-bailable offense?
So bail and non-bailable offense, like theft is a non-bailable offense. If you are caught for theft, police cannot release you. You will be produced before the court, and court will grant you bail. That's bail in a non-bailable case. A twin bail is something altogether different. In like really serious cases of like commercial quantity of cocaine in terrorist activities, those twin bail conditions have to be satisfied, wherein you have to prove to the court you are innocent in the bail hearing only. That's the difference.
So we have next question uh, from Mr. Ashutosh. What about in national investigation matter? They extend the specified time with the consent of the court more than 90 days.
So see, these special acts are very situation specific. In NDPS Act, you have 180 days. In these terrorist activities case, the duration might be something else. And yes, court has the right to do so. But investigation authorities have to specifically seek the time and give the reasons why they could not do the requisite in the given time frame. So in special acts, even the time to file the challan goes up. In NDPS Act, it's 180 days. In different acts, it changes accordingly as per the context. And the investigating authority deserves the right to seek extension even in those time frames. So it depends on the very context of the statute.
So we have next question from Mr. Preet Mehta. In regular bail applications, how do court balance the gravity of offense versus the right to liberty?
Usually, bail, not jail. It's that simple. If the person doesn't have antecedents, if he is not a flight risk, if he has roots in the society, if he has a family to look after, if he is traceable, he will be granted bail. If he is the first time offender, even if it's the murder case. If there are multiple accusations against him, if he has a running history, then it becomes difficult for obvious reasons. So yeah, rather than gravity, his conduct, his standing in society matters. Because at the end of the day, you will prove his innocence or guilt at the end of the trial. All you want him to come in the trial and not to affect the whole trial adversely.
So we have next question from Mr. Avinash Das. Can you please repeat the POXO judgment that you mentioned?
Dharmender Singh versus State, Delhi High Court. Dharmender Singh versus State, Delhi High Court. And,
So we have
and in the and in the compilation, I have given my email ID. So anyone who has query or detailed query, they can give me an email and I will be replying to it. No worries.
So we have next question from Ms. Riddhi. Can police grant bail if a small quantity of contraband has been acquired from the accused?
For that to happen, it has to be a bailable offense, and unfortunately, it is not. Even for a small quantities, you need to go to the court.
Thank you, sir. Um,
So that's all.
uh, yes, sir. Thank you so much, sir, on behalf of all the participants. And so we have one more question. Sorry to interrupt. We have one more question. Are there any specific grounds for anticipatory bail, or it can be granted in all cases before arrest?
See again, in a special statutes, you need to satisfy the law, the conditions given, the conditions which we have discussed in detail. In rest of the cases, the burden remains the same. You have to show that you have been falsely framed, and this whole thing is accentuated with an evil intention to defame you, to harass you. You need to prove all that. So in anticipatory bail, you have a burden which you need to discharge. But again, if you are seeking anticipatory bail in a terrorist case, then your burden is very heavy, and I doubt whether you would be able to discharge it or not.